Lord Hughes will give the judgment.
This was a case about the scope of a new offence of causing death whilst driving uninsured. The defendant, Mr. Hughes, was driving impeccably when an oncoming car veered across the road to its wrong side and smashed into him. The oncoming driver was under the influence of drugs, and he'd been driving dangerously for some distance. He alone was at fault, and he, sadly, was killed in the collision. It was agreed that there was nothing that the defendant did to contribute to the collision, and there was nothing that he could have done to avoid it. However, the defendant was uninsured. Insurance for drivers is compulsory so that anybody injured on a road isn't left without compensation. If someone drives without being insured, everybody else's premiums have to be increased a little so that the compensation can be provided. It is an offence to drive without insurance. Some who commit that offence are uninsured by mistake, perhaps without realising it. Others do it deliberately. This defendant did it deliberately. So his driving without insurance was serious, and he was liable to be fined heavily and disqualified for that. But he wasn't charged with driving without insurance simply. He was charged with a different, recently created offence of causing death by driving when uninsured. This is a form of homicide, like causing death by dangerous driving or causing death by driving under the influence of alcohol. It carries up to 2 years imprisonment, quite apart from the other consequences of having a conviction for having killed somebody. The question for the court was whether that offence is committed simply by being on the road and being in a fatal collision, or whether there must be something in the driving which caused the death. Our conclusion is that because the statute uses the language of causing the death, it must mean that there has to be something in the driving which causes that death. It is not enough just to be on the road. It would have been possible, of course, for Parliament to create an offence which is committed simply if your vehicle is involved in a collision resulting in a death, and if at the time you were uninsured. That could have been done if that had been what was meant. By contrast, this Act of Parliament makes it an offence to cause death when you're uninsured, and that calls for something more. No doubt one could say that but for the defendant being on the road, this particular fatal collision wouldn't have happened. But that would be much the same as saying that if the other driver had hit a tree rather than this defendant's oncoming vehicle, whoever planted the tree had caused the death. The law draws a distinction between things which are but for circumstances, which are simply the background to an event, and on the other hand, things which truly cause that event. So the conclusion is that this defendant was not guilty of this offence of causing death, although he was guilty of the separate offence of driving without insurance.